When he asked me to become a Chancery judge, I was completely knocked sideways. I actually said no the first time, I just wasn't ready. None of us, whatever our views about Brexit, thought it was anything to do with Brexit. It was a purely constitutional question. If the courts couldn't have done anything about it, nobody could. You're never going to have a system of law where you like everything about it. I think our criminal sentencing, certain aspects of it, when I was a judge, were utterly unacceptable. After I'd been round Holloway, I just thought, I'm not going to send a woman to prison.
Because of the conditions?
Oh, it's inhuman, I thought.
This is The Judges, Power, Politics and the People, hosted by the University of Law. I'm Frances Gibb. This week, I'm speaking with Lord Neuberger of Abbotsbury. David Neuberger reached the heights of the judicial system, sitting first as a law lord and later in the Supreme Court, becoming its president in 2012. It fell to him to lead the Supreme Court in one of its most high-profile decisions in recent years, on whether the government needed the approval of Parliament before triggering Brexit. He was also Master of the Rolls, head of the civil justice system. His rise to the Court of Appeal and then to the House of Lords is one of the quickest in recent times, and he was only 59 when appointed a law lord. Lord Neuberger went to Westminster School, then read chemistry at Christ Church College, Oxford. He began his working life as a banker before going into law. He came from a family of high achievers. All three of his brothers were or are professors, as was his father. I began by asking Lord Neuberger how he chose the law as a career and what influenced him.
It was a slightly crooked journey. At school, I was actually interested in history, but the school and my parents thought I should do something more disciplined, and I was really given the choice between science and classics. And I think because my father was a scientist, I chose science. And I wasn't a particularly natural scientist, to use a slightly unintended pun, but I, having got reasonable but not very distinguished A-levels, in these days not nearly good enough to get into a good university, but in those days, as a man, getting into Oxford and Cambridge from a private school was much easier. I got into Oxford and I read chemistry for 4 years, which included a year's research.
But you didn't want to become a chemist?
Halfway through the year of research, I looked round and saw people who were better than me, keener than me, and I thought I should do something else. And I went to the careers people at the university, and they did a bit of what would now be called isometric testing, I suppose, and said it's either the law or finance. And in those days, finance didn't involve exams, and I'd had enough of exams, so I went into banking. And I've said this before, if I was a bad chemist, I was a worse banker. And I was not a good banker. And after 2 years, I thought, I was 25, which seemed old at the time, seems very young now, when I thought, I've failed. All my friends are on their careers, and I've just hit a dead end.
Yes.
And I was walking home feeling dejected, and I met a friend who'd been at university with me, who just started at practice at the bar and was going round the county courts doing cases. We went off for a drink, and he described what he was doing, and I had a sort of Damascene moment. I also have to admit that I was prejudiced against the law by my mother, who was a great influence on me, and she didn't approve of lawyers at all.
Well, she didn't, I think you said, she didn't approve so much of you becoming a barrister, but she was quite happy when you became a judge.
She was very pleased with me being a judge, but she felt that barristers, to use her words, were smart Alecks who argued on behalf of whoever paid them, which is true, but perhaps I was a natural smart Aleck. But so funnily enough, she trained me for it because I was an argumentative boy. And she would get a bit fed up sometimes and say, OK, let's change sides. You argue what I'm arguing for.
So when you became a barrister, had you already kind of thought to yourself, I'd like to end up on the bench?
No. I I see myself, and this is probably not true, but I see myself as having quite low self-esteem because I had 3 pupilages in very good chambers, commercial chancery chambers. And the problem came, who were they going to select to join chambers?
Yes.
And
So you didn't get in straight away.
I had 3 sets of chambers where they chose somebody rather than me.
And that was a bit dispiriting.
And it was quite dispiriting. So my spirits were low to begin with, having had 2 failures in science and banking. And then I didn't seem to be getting anywhere at the bar. And so it sounds rather unkind to the chambers I joined, but I had to lower my aim. And I joined a set of chambers that specialised in landlord and tenant law that I knew nothing about and had no interest in. But any port in a storm, I could get in.
You could get in. And did you enjoy being
I
at the
loved it. I have no doubt that it's a lesson for life, that I enjoyed it and did far better than if I'd joined any of the 3 chambers I would have rather joined.
And then the progression to the bench, that was a natural one, or did you think, I'd actually like a change?
I thought when I joined my chambers that I would, when I was sort of 55 or 60, have to decide whether I wanted to become a circuit judge or not. It never crossed my mind that I'd be a High Court judge, and Chambers had never had a High Court judge.
And was it still the tap on the shoulder? How did you come to be a High Court judge?
In 1993, I was at home having dinner with Angela, my wife, and the telephone rang, and a voice said, "This is the Lord Chancellor's secretary. The Lord Chancellor likes to see members of the bar from time to time. Would you call on him?" And gave a time. And because my chambers didn't have any sort of history of appointments, I had no idea this meant I was going to be offered a High Court judgeship.
How did he know you?
I was doing a case to do with business tenancies, which are governed by a statute, the Landlord and Tenant Act 1954, in front of Nicholas Brown Wilkinson, who was then the Vice Chancellor. Now it would be called the Chancellor. And it was going quite well, and he asked me a question. And the question involved rather an intricate analysis of schedules to the Act, rules of court, going back to the schedules. And it was absolute bread and butter for me, but it was totally new for him, and I could see he was visibly impressed. Well, after he'd given judgment, 2 days later, my clerks got a message from the Vice-Chancellor's clerk saying the Vice-Chancellor would like to invite Mr. Neuberger to sit as a deputy. And that's how it happened in those days. And when he asked me to become a Chancery judge, I was completely knocked sideways. I actually said no the first time. I just wasn't ready.
You didn't think you could do it?
I was 45 and I just felt financially, psychologically, I don't know, I just didn't feel ready. So I sort of said off the top of my head, perhaps I could come back in 3 years. And they came back in 3 years, and I said,
so they
yes.
literally stuck to the 3 years, did they?
They did.
And then
That's an interesting development, because I gather in the days of Lord Hailsham, his answer would have been, it's now or never.
That's right.
Whereas Lord Mackay was a much more
understanding person.
He was a great man, actually.
Yes. So off you went onto the High Court bench, and then you had a meteoric rise.
It wasn't that meteoric.
Well, you were a law lord at a very young age, weren't you?
It was meteoric, if you like, and we know what happens to meteors; they burn out. But it was quick from the Court of Appeal to the House of Lords.
Yes,
that was quick.
indeed.
But I was 8 years a High Court judge,
Yes.
and in a way,
well, you were young. I think that's the thing people remember. You were the youngest. I
that's
think.
what they said. But it's pretty likely you'll be the youngest when you go there, because you're the most recent appointment.
So you reached these high echelons, and first of all, of course, it was the law lords. And did you have a sense when you were there of the power of that position? What was it like? Did it seem as though you were right at the apex of the justice system and you had great power to change the law and to make law?
I think it sounds very boring. I think I was aware that, subject to the European Court of Human Rights and legislation changing your decision, and I suppose subsequent House of Lords saying you were wrong, that you were the last word. And that was quite a feeling of responsibility.
An enjoyable one? Did you enjoy being in the House of Lords?
It didn't worry me. I mean, one of the things, even post-human rights, is that in terms of sort of political power, the judiciary in this country is pretty limited. I think it's a good thing, so long as Parliament remains sort of sensible. But you compare us with the US Supreme Court, and we don't have significant political power.
Absolutely.
And it's a very good thing. Look what happens when you do.
I think, would you say then, looking back over the time that you were a judge, that judges have more power than they did or less, since we now have the Human Rights Act?
Undoubtedly. From when I started in 1975 at the bar, there is no doubt that for 45 years, it's all been one way. The enormous growth of judicial review for various social, political, and judicial reasons, the introduction of the Human Rights Act, the European Communities Act, which also gave judges unusual powers by common law standards, and above all the Human Rights Act, but also acts like the Data Protection Act and even more the Freedom of Information Act, statutes like that, have undoubtedly meant that judges' powers have increased substantially.
So as a branch of the Constitution, the judiciary is actually stronger than it was, say, 30 or so years ago, would you say?
It is definitely stronger. It's definitely got more powers. But by the standards of the United States, we are way behind, and healthily so, in my view.
What was the difference once you reached the Supreme Court from being in the House of Lords? Was it very different?
The Supreme Court, the move to the Supreme Court, definitely gave the judges more of the court, the justices, more of a sense of identity, more conscious of their position, because of the public perception. It was almost a reflection back of the public perception. I mean, nobody knew who the law lords were. Plenty of very experienced lawyers didn't actually know who the law lords were.
And you were stuck in a little tiny dark corridor.
And some people thought they were members of the House of Lords who sat as judges rather than judges who happened to be members of the House of Lords. Whereas the Supreme Court, to use that tired expression, it does what it says on the tin. And people knew what you were. The public had easy access. We had control of our own procedures in a way we didn't as law lords, because the law lords were technically a committee of the House of Lords. You had the fun of going into the House of Lords chamber to give your decisions and that sort of thing.
Yes, you had that little rigmarole.
And you were in the House of Lords, and you got a peerage if that is, if that's important to you. But the Supreme Court it's definitely an improvement. I mean, I was one of those who was a bit equivocal about the change, but I think those who supported the change have turned out to be right.
And in terms of public perception, as you've just touched on, it was better from the public point of view, viewing the judiciary as a completely separate
I think that's right. And also they were able, I mean, they could have done these things in the as law lords, but giving out. But I think it also introduced a feeling of freedom and a feeling of self fulfillment and self-fulfillment. You could do what you wanted. So, they introduced this idea of publishing summaries of their decisions, reading out their decisions in public, having videos of streaming their hearings, which they could have done in the House of Lords, but somehow the psychological factor was very different when you went to the Supreme Court.
You were much more accessible, more easily understandable, but did it also make the judges more open to public scrutiny? People suddenly thought, who are these people?
In practice, it did, yes.
Sitting at the apex of the system, making these key rulings.
But fortunately, although there were moments when Boris Johnson was Prime Minister that there were criticisms and threats even, but on the whole, there hasn't been much, my impression is, there hasn't been much dissatisfaction. I mean, there have been the odd moment like the the attacks by the press during the Brexit cases
That's
and that
right.
sort of thing.
Well, that's what I'd like to come to. And just before we leave Boris Johnson, or perhaps as we come to Boris Johnson, when you say there were attacks, you mean attacks by ministers on the judges?
Yes, but when you look at it, there weren't many. And you look at other countries, and we are extraordinarily free of that. The politicians, even the more extreme, the more emotional ones, are rarely critical inappropriately of the judges. I mean, you have to be careful about being oversensitive. For a politician to say, I disagree with the decision and we're appealing, absolutely entitled to do that. But to start attacking the judges, that's not on. And we have that very rarely.
Of course, we did have it famously, as you've mentioned, with the Brexit enemies of the people ruling. And you led the court, which then went on to endorse that decision. What did you think about the attacks on the judiciary the first time round when the Lord Chief Justice was leading the court? What did you think about that?
Well, that was a bad moment. But what was particularly, why it hit people particularly strongly was because it was such an unusual event in this country for the press to be doing that. And on the positive side, that highlighted the fact that it was very rare. And also on the positive side, it hasn't happened since. The second Miller case was more controversial, I thought.
About the proroguing of Parliament.
I want to make it clear, I think they got it right for the right reasons. But it was more controversial politically and indeed legally, I think. But the press, although partisan, was much more reasonable and sensible in their criticisms.
It's true. The enemies of the people ruling, I just asked you what you felt about it, because you then are faced with having to either endorse or not that ruling. And it had become very personalised, hadn't it? I mean, the way that the tabloids delved into the background of the judges who made the decision. Did that make it, when you were sitting there as the Supreme Court, was it difficult for the judges? Were people anxious about it?
I think there are two answers to that in a way. I had a particular problem because the press cottoned on to the fact that Angela, my wife, tweeted one or two things that made it clear that she was against Brexit. And one or two people said I should therefore recuse myself. I dealt with that, having thought about it, by writing to the parties saying I was intending to sit all 11 justices, because we had one vacancy, fortunately, because we can only sit an odd number. And I just wanted to give the parties an opportunity if they wanted to object to any of us sitting.
They didn't.
And I took a calculated risk on that. I thought the only people who might object if I'm thought to be anti-Brexit would be the one side that, as it were, is pro-Brexit, and that was the government. And the thought that James Eadie or the government would object to me sitting was, I thought, remote in the extreme. So I took that risk. And if you run the hearing, at the beginning I made an announcement about one or two things, and I said that I'd written to the parties, because I thought that was the best way of dealing with it.
I remember, yes, you did.
But on a more broad basis, I think it sounds, I don't know, a bit smug, a bit, I don't know what, but actually I quite enjoyed the pressure. It was like being back at the bar, and you just had to watch what you did and watch what you say and be careful about it.
Well, were you worried? It turned out to be a ruling 8-3, wasn't it?
Yes.
Were you worried that it might be 6-5?
The reason I had 11 was threefold. One was to signal that I thought was very important. Second was because of the very point you've identified. If I'd sat even 9 and we'd been 5-4, people would have said if the other two had sat, it might be the other way, whereas if I sat all 11, that couldn't happen. And thirdly, I knew all my colleagues wanted to sit on it, and I didn't want to make enemies of some of them by saying they couldn't sit.
Everybody wanted a share in that.
Exactly.
And it was, we'll come back to the prorogation one, but it was nonetheless a pretty political ruling. And I suppose people, members of the public, will ask, well, how could these judges make that decision in an unbiased way? That's what people say. And leave their politics at the door of the court. How can they do that?
I think it was very easy in that one because none of us regarded it, despite the press and politicians, as remotely political. I mean, the issue was, did the government, in the form of the cabinet, need formal authority from Parliament in the form of a statute before it could pull out of the EU? And by saying that they needed the approval of Parliament, it didn't seem to me, A, that was a sort of party political or pro-anti-Brexit decision, and B, it seemed to me actually obvious that Parliament was going to say yes after the referendum. And to be honest, what really sort of amused me, if that isn't too pompous a word, was that I thought actually the press and the politicians had it the wrong way round. I would have thought that if you were anti-Brexit, it was much better for the cabinet to pull out of Europe without the approval of Parliament and run the risk of Parliament saying, we never approved this. Whereas once you've got the approval of Parliament, that was
the
sealed.
Final seal of approval.
So,
it gave it the authority.
Exactly. So it seemed to me that we were in an Alice in or Alice through the looking glass.
Yes, it was a
situation.
strange analysis. It was.
It was. But none of us, whatever our views about Brexit, thought it was anything to do with Brexit. It was a purely fundamental constitutional question. We all agreed on the fundamental constitutional issues. Where we disagreed was on a point where Robert Reid, Robert Carnworth and Anthony Hughes went the other way from the 8 of us, which was whether Parliament had already authorised this under the European Communities Act 1972. And that was quite a nice point of statutory construction, on which quite a few people think Robert, who wrote an excellent judgment, of course,
yes,
quite a lot of people thought he was right.
Yes. And of course, people will say, despite all that, people will say it's impossible for judges to leave their prejudices at the door of the court, and you must get asked this all your life, or have been asked. Is it possible?
It's a ticklish question. I mean, the trite answer and the easy answer is, first of all, because we're talking about the subconscious, it's impossible to know. And secondly, we all do our best to put our prejudices and personal beliefs behind us when we reach a decision. The truth is that, of course, to some extent, you are influenced by your personal views. I mean, obvious views about the need for justice, the need for fairness that nobody would quarrel with. And how you're influenced by your own particular views is quite difficult to tell.
Yes.
It's the argument for a degree of diversity in the court, not diversity in the popular, obvious sense of gender and ethnic diversity, but in the sense of diversity of outlook. But again, it's a slightly nuanced question. Logically, if you want a complete diversity, you would have criminals and drug users because they need representing, and nobody suggests that.
Absolutely.
So it's not as simple a point or as clear-cut a point. And those judges who say, of course, we leave all our prejudices behind us and we're completely neutral. I mean, that's just not
unrealistic
human
as
nature.
well, isn't
One
it?
has to accept there is a degree. And you just have to look at the court when I was there, and you can see when it comes, for instance, to upholding or interfering with government decisions, there were judges who, not in a party political sense, but who in a more in terms of a sort of general constitutional sense, were more ready to interfere with government decisions than other judges. And that's natural.
You mentioned the other very high-profile ruling of the Supreme Court, and I think you weren't there by then,
no,
the prorogation one, and that was unanimous.
It was.
Do you not find that rather extraordinary?
Actually, it's a very interesting one. When I first heard of it, I thought the government was right. But before they gave their decision, I sort of looked into it and discussed it with friends. And there were two steps in the reasoning, and I thought that actually when you started to analyse it, the two steps were obviously right. The first was a purely pragmatic approach. But if Boris Johnson had turned up on the floor of the House of Commons and said, you are prorogued for 2 years, if the courts couldn't have done anything about it, nobody could. So surely the courts had to come in and say, this won't do. And the second thing was, this wasn't 2 years, this was 6 weeks rather than 3. But on the evidence, the court had John Major and a former permanent secretary of the cabinet, I think, saying that you never need more than 3 weeks. And the Prime Minister came up with nothing as to why he needed more than 3 weeks. And the reason, I'm afraid, I think, was that he had said publicly on more than one occasion that it had nothing to do with Brexit. And in fact, I think his reason was, I don't want Parliament making a nuisance of itself while I'm negotiating Brexit with the Commission and the EU. And I think if he had been able to run that argument as to why he wanted it, it would have faced the Supreme Court with a really difficult question. Was that a proper reason for having 6 weeks? But he didn't come up with the reason.
He didn't, of course.
So what was the court to do? They had evidence one way.
3 very senior judges, including the Lord Chief Justice, Lord Burnett, had already ruled that it was okay.
I know. But,
so the 11 Supreme Court justices were overruling 3 other very senior judges.
Yeah, but I think they were right for the reasons I've given.
Do you?
I mean, all judges are human, although sometimes it's a bit hard to believe in some cases. But and all judges sometimes get it wrong. I mean, I can think of cases. I decided 250 cases in the Supreme Court about. Didn't write judgments in all of them, but I was party to them. It's inevitable that I was wrong in some of them. And judges do get things wrong, partly because they simply jump the wrong way sometimes, partly because the arguments sometimes aren't properly put to them. And sometimes because for other reasons, but normally you don't get it right all the time. And they didn't get it right, I don't think.
I think our judges were very taken with the idea that it wasn't actually for them to interfere.
Quite, but if it wasn't for them...
You're saying who was it for?
Who was it for? That's what the court's there for. And interestingly, although some people attack the judges for being anti-democratic, the 2 most controversial decisions of the court in recent years, Miller 1 and Miller 2, both involved the court saying it's Parliament that rules, not the executive.
These are the 2 cases we're just talking about now.
The 2 cases we're talking about. In the first case, they said...
The Brexit case and the prorogation case.
In the Brexit case, the court said the executive cannot take a step as awesome as leaving the EU without Parliament approving it. In other words, Parliament rules. The democratic voice must be heard. And in the second Miller case, the prorogation case, the court said the executive cannot shut down Parliament for more than is necessary.
So the judiciary was asserting the authority of Parliament over the executive.
In each case, this is the irony.
Yes.
The far from being anti-democratic, the court was protecting the democratic institution from the overreach of the executive.
Another high-profile case that you handled when you were President of the Supreme Court was the very sad case of Tony Nicklinson, the man with the locked-in syndrome after he'd had a stroke, who sought the right to be helped to die. And that was a very controversial case. And you, I think, led the ruling on that. You did find it in breach of human rights, but you thought it wasn't for the court to interfere and change the law. Is that right?
I think I was a bit more equivocal than being in breach of human rights, but you're pretty close to what we said. I hinted that that was our view. I think 2 members of the court, the 2 who were most ready on the whole to rule against the government, held that it was in breach of human rights and the law should be changed. 4 of my colleagues, more conservatively inclined, were of the view that this was not for the courts at all. And 3 of us were of the view that unless Parliament got skids under and dealt with it properly, the courts should consider stepping in. I was quite surprised because I thought the message from the Supreme Court, which came out of that with 9 judges, was pretty confused and pretty unclear, and I thought it would be greeted with some, not derision, but some disapproval. But curiously, because there were judgments there that everybody could like, depending on your view, it was quite well received. But it was a difficult one. And the thing I found most disquieting about it, picking up a point that you made earlier, was that of all the cases I was involved in, it was the one where it was most difficult to detach your own feelings from the decision.
Did you think yourself the law needed changing?
I was and am in no real doubt from my own personal view, although I understand other people's point of view, that the law should be changed, yeah. But
you didn't feel it was your role, because
exactly.
you could have led your colleagues, presumably, given that you were chairing the court, could you not have led your colleagues round to that view?
That's very nice of you to think that. I think that three of us were in genuine doubt and uncertainty about what to do, and 6 were pretty clear in their minds.
That you shouldn't change the law?
Well, no, I think that the 2 who thought we should change the law, 3 of those who thought we shouldn't change the law, and 1 of those who was in the middle were pretty clear. And then 1 who thought we shouldn't change the law, and 2 of us who were in the middle, including me, were very unsure which way to go on this one. But
you were unsure about whether you should be saying, whether the court, which it had the power to do, should recommend a change in the law.
My colleagues frequently tease me about the fact that I was always the one who could see much to be said on all sides. And on that one, I really could have gone any one of 3 ways. I really could see all 3 arguments.
So do you think the court reached the wrong decision on that? Because, of course, the law hasn't been changed.
Well, personally, I regret it because I think the law should be changed. Do I think the court reached the right decision now? I think, well, I've got to be careful here. I've always said that you should, once you've given the decision, you should never say whether it was right or wrong, because particularly you should never say it was wrong, because you put everything in great confusion. Somebody cites your judgment to a High Court judge, and the other side says, but Lord Neuberger's just said in public he thought he was wrong, you know. But I have to say in Nicklinson, not least because our decision wasn't absolutely sort of clear, I think it probably was the right decision. I think it reflected public opinion to the extent that public opinion is divided. But personally, I regret it because I think the law should be changed. My heart was with Brenda and Brian, the 2 who said the law should be changed. That's what I would like to have done. But I felt that wasn't right for us to do it then.
And was it, yes, and presumably a factor was the thinking of the constitutional role of the judges. Did people take the view it wasn't really for judges at that point anyway to change the law at that moment?
The argument the other way is that because of the clever way the Human Rights Act is drafted, we weren't changing the law. We were simply saying, we would have been simply saying, we think Parliament should change the law.
That's true.
I do wonder sometimes whether I should have got along with Brenda and Brown said that. But I also wonder whether in our system it was right to say this isn't for the judges at all. So as I say, it's
interesting.
It's right to say I did agonise about that one.
Yes, interesting.
And I'm by no means confident I was right and that the decision was right, but I certainly don't think it was wrong. It's one of those to which there isn't a right answer.
No.
Sometimes you agonise and eventually you work out, yes, this is what I think, definitely. But sometimes you do feel, sometimes even when you're just handing down the judgment, you think, did I get this right?
Yes, quite a responsibility.
Yeah, but a point comes where you've just got to say, this is it, I've got to get on.
So you wouldn't worry about it afterwards?
Yeah, I do.
You do?
Yeah. Pathetic, because there's nothing you can do about it.
But it's natural, a human response.
Some people are better about it than others, but I did There are some cases that I did worry about afterwards, yeah.
Other than that one, can you mention one other maybe that you worried about?
Do you know, the one that sticks in my mind is a 10-day case I did at first instance about an individual who represented himself, who the charity commissioners wanted to debar from being a trustee because of the way he'd conducted a trust. And it was a sort of slightly odd religious trust. And everyone was very difficult. And at the end of the day, I gave quite a long judgment saying, on the whole, I thought it would be better to debar him from being a trustee again. And he was very upset by it. And I think I was wrong. And it's a case of no legal significance. I just applied well-established principles. He tried to go to the Court of Appeal. They said it was a matter for the judge. But
so he didn't succeed.
I really upset, probably for the rest of his life, one person. I said he was acting in good faith and everything, but I really upset him by a decision that I think was simply wrong. That's the one that gets to me most, although I'm sure I got much more important decisions wrong, but that was a sort of personal one.
Is he alive now, this man?
No, I'm sure he isn't. And you can't get in touch. I was tempted at one point to get in touch with him, and I think that would probably make it worse.
Yes, it probably would.
It's like confession.
Well, you're very honest about it.
Yeah, well.
Sorry.
I was going to say, I think the one I was trying to justify why worrying about a case after you've given judgment is worth it, because on the face of it, it's pretty pointless. I suppose the only benefit is it's quite good to remind yourself that you worry about it afterwards, so you better get it right.
Indeed.
So maybe it's got that benefit.
You wouldn't want to become case hardened as a judge, and some people do.
You have to a bit.
Oh, you do.
Otherwise, you have a nervous breakdown. But you mustn't be too. Yeah, you're right.
Well, if you were cautious, not quite the same point, but if the justices were cautious on the Nicholson case, over the years they've been much less cautious about inevitably about creating the boundaries of privacy law. And you, when you were Master of the Rolls, head of the civil justice system, you sat on a whole inquiry into the use of injunctions, super injunctions, which created privacy rights. Looking at the law now, what do you think should happen? Should we have some law enacted, or should it just go on being done incrementally by the courts, as seems to be happening?
I think one of the problems about legislating is that legislation takes a long time, and the world of the media is moving quite fast. And in a way, it's better left to judges because it can be developed
on a case-by-case
basis as the media change. Whether the media is changing now enough and whether the law is sufficiently clear enough, I'm not sure. But you could argue if the law isn't sufficiently clear, we need more time for the judges to develop it. And if the law is sufficiently clear, then we don't need a statute. But I think if we have got ourselves in a bit of a mess on it, or Parliament feels the judges are going in the wrong direction, then of course there should be legislation.
I think what's made a difference is social media, which is obviously unregulated in the way that the traditional press are regulated.
I think that's right. And the other thing, of course, is that you can use a server outside the jurisdiction to get into the jurisdiction, which means enforcement is very difficult.
And the power of the judges to create or shape privacy law, that really comes from, and I think you've made this point, the Human Rights Act, which you said gave the judges more power than anything really in the last 30 years. Is that correct?
This is why it's a little ironic for politicians to attack the judges for having, as it were, grabbed more power, because by far the biggest bestower of power on the judges has been done by Parliament in the Human Rights Act. The reason why privacy is particularly highlighted and particularly criticised is, of course, because it's the media who do the criticising, and privacy is not something they like because it intrudes on their ability to report. So it is the conflict or the tension between Article 8, the right to privacy and family life, and Article 10, the right to freedom of expression, is very, very difficult. And the difficulty about Parliament enacting legislation is that cases are so fact sensitive that all Parliament can do is lay down the principles and the courts then apply them to particular facts. And already, I think, in the Human Rights Act, the importance of freedom of expression when privacy is being claimed in that connection is emphasized. But if the press had its way, and I'm not saying they're wrong or right, it could be even more emphasized. But the trouble is it's a balancing exercise and it's very difficult. As a judge, when you're saying I've got to balance various factors and see which outweigh the other, in the end, however long your judgment, however close your analysis, it's one outweighs the other because I say so. And you can explain it, but in the end, it isn't a sort of, you can't do it as a mathematical exercise.
Do you think that, well, if the Human Rights Act has given more power to the judge's elbow, if you like, what about Brexit? What's that done? And we've had recent threats, they haven't come to anything, to ignore rulings of the European Court of Rights. I mean, what do you feel about all that?
Brexit has nothing to do, in theory anyway, or in principle, with human rights, as you know. Indeed, in the sort of 2005 to 2010 period, the Conservatives' main concern was with human rights, not with the court in Luxembourg. I think
it's sort of gone hand in hand, hasn't it?
They have seen, well, most people didn't realise that. If you ask most people...
they won't know.
Indeed.
Yes.
When I said to people who supported Brexit and they sort of objected to the Luxembourg court, or the European court, as they'd call it, I'd say, what decisions do you most object to? And they would all be decisions of the Strasbourg court, mostly about asylum seekers.
Yes. In recent years, we've seen, though, alongside Brexit, we have seen attempts, proposals for a Bill of Rights, and even mention of ignoring Strasbourg
but to be fair, that predated Brexit as well, with Chris Grayling that was going on.
That's true.
And we've seen it again. I mean, I think...
Is that a threat to the judiciary and the power of and the standing of the rule of law, I think, is more...
It's a threat to the rule of law. I mean, either we're in the Council of Europe or we're out of it. And if we're in it, we've got to observe their laws. We've seen the unedifying sight of attempts by the government to introduce bills into Parliament which involve Parliament approving the government breaching its international obligations.
Yes.
Including those that the Prime Minister entered into 5 minutes before he produced the bill. Well, 5 minutes is an exaggeration, but it's not much, which is a serious threat to the rule of law. I mean, if a government expects its citizens to obey its laws, it's not a good start if it feels itself and pronounces that it is free to flout its legal obligations on the international stage.
Do you think that the attitude of ministers in recent administrations does put the rule of law at risk?
One or two ministers, but in the end you have to judge things by what happens. And while I can fulminate against things like the Internal Markets Bill and the Northern Ireland Bill, they didn't happen. And in the end, and while there were threats about getting rid of the Supreme Court, and there was a threat to introduce this ridiculous human rights bill, but none of them have happened.
You mentioned earlier the US Supreme Court, and those are obviously all political appointments, and we haven't got that. I mean, political elements to other appointments here comes up from time to time. When you were on the Supreme Court, you were involved, I think, in the appointment of the Lord Chief Justice. And the Lord Chancellor of that time, Liz Truss, set the rules and said that the next incumbent must be able to serve 4 years. What did you think about that? Because by that change, that eliminated two candidates at that time, Brian Leveson and Heather Hallett. They were automatically excluded then from the frame. Did you think that was the right thing for a minister to do?
No, I didn't. I thought it was quite inappropriate. We did consider ignoring it.
Did you?
It was advisory in the end. But if we'd ignored it and appointed somebody who had 2 years to run, and the Lord Chancellor had then turned that person down, it could have led to a real potential crisis.
That would have been a real conflict. That she could have done, couldn't she? Because you recommend a name.
Ironically, she couldn't have done, because by the time we came up with the name, she'd been junked.
Oh, right, yes.
Temporarily. And we had the excellent David Lidington as Lord Chancellor.
Right. But had she been in position?
Had she been in position, yeah.
And of course you didn't know that, I suppose.
I mean, there was a... Yeah, I can't go into details, but there was serious discussion about whether we should...
just carry on as though she hadn't made that prescription. Yes.
And I'm not going to say who said what, but there was a serious discussion about that. I suspect we were influenced by the fact that there were, in any event, good candidates. We weren't being deprived. We were deprived of 2 very good candidates, but we were not left with nothing.
Exactly.
I mean, obviously there was one very good candidate who got the job, but there was more than one.
And are you, apart from that, which was somewhat of an aberration, do you think the system works quite well?
To some extent, it's a question of personalities. If you have a very good Lord Chancellor, like the 2 last old-fashioned Lord Chancellors we had, Lord Mackay and Lord Irvine, then the old system was very good because they were excellent and they appointed without political or any other bias. They appointed on merit, and it was very quick. Now you have a competition that might take 3 months to decide who's going to be Lord Chief Justice. Yeah. Then you've got the vacancy in the Court of Appeal. You've got another 2 months while they try and go through the competition, etc. So it's far more time-consuming and bureaucratic. And that is undoubtedly a negative.
Does it affect the quality of the appointments?
Initially, I think it did, because there was a risk that it did. I can't say I've done a survey, and even if I had, I wouldn't be reliable. But I think a number of people who hoped and expected to be tapped on the shoulder didn't want to have the indignity of having to apply and risk being turned down.
Well, of course, now we have our first woman.
Yeah, that's good.
Lady Chief Justice. Will that make a difference to the public perception of the judiciary, do you think?
Yes, I think it will. If you ask somebody to draw a picture of a judge, they will draw a man. And I think that having a woman Chief Justice will help emphasise that the judiciary is more open, more diverse than most people would think of it as being.
You've always been very keen on diversity, of course, in the profession. You've chaired a report on it.
Yeah, I think diversity is important. It's easy to talk about and difficult to achieve. The most difficult area is socio-economic background. I mean, gender, the main problem about gender or sex or whatever the correct word is to do with, is not in the judiciary. The problem is at the bar and among solicitors. It's not at entry stage where there are more women who become solicitors and probably almost as many women as men become barristers. But it's the progress. You look at the number of KCs, 13, 14% who are women. Look at the number of senior partners in large firms who are women. It's 14%. So in that sense, the judiciary has a lot to be proud of, because the judiciary is fishing in that particular pond of top practicing lawyers, and there are 14% women, and High Court is over 25% women. Now that should be 50%, I freely accept. But bearing in mind where they're fishing, they're doing quite well.
I want to ask about Hong Kong. What's your argument for saying you should carry on sitting there?
Well, the simple argument is, A, if we go, the idea that things will get better is a joke. Things will get worse, if anything, not better. Secondly, if we go, we are undermining the judges who stay, the permanent judges, and there are a lot of good judges there who are doing their best. And, you know, the judges in the top courts are, in many cases, just as good as the judges here, and they're doing a good job. And if we go, we're basically saying to them, we think you should go. We don't think you've got the rule of law. And that would be knifing our colleagues. A point may come where we have to, I accept, but it's a pretty heavy thing to do. Thirdly, you're never going to have a system of law as a judge where you like everything about it. I think our criminal sentencing is, and certain aspects of it when I was a judge were utterly unacceptable, but I didn't resign over it. I sat in Privy Council cases where countries had the death penalty, and I think it's entirely wrong.
Is that the aspect of criminal you're referring to?
No, it was things like IPP and that sort of thing.
Yes.
And personally, I think our sentencing is savage in many cases, quite inappropriately high. It's a personal view.
Do you think it's got ratcheted up?
Yeah, it's got ratcheted up. Yeah. That's my view. I think in some areas.
When you say it's savage, you mean people sentenced to prison for minor offences that they shouldn't go in for?
I think that some of the long sentences are far too long. But I think actually the worst thing is the short sentences. Having visited prisons, I see people being sentenced for 6 months, which in some cases ruins their private life, their family life, their wife or husband, normally wife, leaves them, or really mucks up their children. It mucks up their employment. 6 months is quite much too short to achieve any sort of rehabilitation or any assistance. You talk to the prisoners, you talk to the prison officers, you talk to the probation officers, they're all agreed on that. Actually, the time I got most adverse coverage was when I visited various prisons and I wrote an article saying, I'm not an expert on criminal law, but the one message I get from everybody in the prisons is that short sentences are a mistake. They don't do anything for the people, et cetera, more or less what I've said, and they clog up the prisons. The Daily Mail had a main headline that got the front page attacking me for being soft.
You and others such as Lord Woolf, you have lent a reputation to the judiciary of being liberal, soft sentences. Lord Woolf was famously called the burglar's friend.
Exactly.
Do you think these are fair comments from the tabloids or the public?
No, of course not. But I mean, the thing is that as a judge, you don't terribly mind about these attacks from the press because you know perfectly well that it'll last a day and it'll go away. And as a judge, not merely do you not want to respond, you can't respond. You're not meant to. You keep quiet. So it doesn't continue. It just dies away. And if it's really controversial, other people will speak up for you because that will get them coverage. So you just let it flow. And you've got a job for life, and or at least till you get to 70 or 75. So you can be quite relaxed. But if you're a politician, it's very different. You know, A, you're expected to answer back. B, there are repercussions for you in your party and your constituency in Parliament. And you're liable to lose your post. So the press have enormous power over that, but they don't have much power over judges.
Of course, some people would say it does show judges are out of step with the general public when it comes to sentencing.
To some extent, that's probably true, but it doesn't mean we're wrong. And secondly, out of step with the public normally means out of step with a particular newspaper. I think, and itself, they're quite interesting tests that have been done. Stephen Sedley told me years ago, and I looked it up and it was right, that one academic carried out a test. How statistically reliable it was, I don't know. But 40 people were asked, you know, are our sentences too low or too high? And about 38 of them said, we don't send people to prison for long enough. And they were all then given case studies. And they almost all imposed sentences which were less than the judge had imposed. I think it's a difficult one, but I think that part of the judge's function is, with care, to decide cases that are unpopular, because politicians can then use the judges as an excuse.
They can. And in any case, you don't have much freedom when it comes to sentencing, do you, really?
Well, there's a sentencing council, but I think when I was a recorder, I sentenced people to prison who I wouldn't sentence to prison. The only time I really went against the rules was after I'd been round Holloway, I just thought, I'm not going to send a woman to prison.
Because of the conditions?
Inhuman, I thought. They did their best, but they didn't have the money. It was not the people.
So when you say the sentencing system is savage, you mean that incarcerating people
I think
for too long
the whole thing is
in bad conditions.
Yeah, I mean, savage may have been a rather heavy word, but there were aspects of it which was savage. The IPP system is savage.
Indeterminate sentences.
Yeah,
for
and there are
public
people who then, having done 3 mini crimes,
and we've still got them inside.
Exactly. I think that is savage. I just think it's remarkable that they haven't all been released.
Well, this Lord Chancellor now may take steps. He says he's going to modify it or try and do something.
I regret the word savage. I think it's a bit heavy.
Well, you said that you modified it later. You said savage in some aspects.
It's a bit extreme. When you've read about or seen films about or occasionally visited prisons in many other countries, we look pretty decent.
Finally, future threats to this position and holding the balance of power. I think you've mentioned before yourself, funding, access to justice, those things. Justice system is poorly funded, but then so is the health service. So are other parts of the public sector. Is that a worry?
Yes. There's always, you never know what's going to happen in the future. We all know nobody expected COVID and et cetera. Nobody expected the Ukraine war and so on. And planning for the future, well, there's something in the argument that God never laughs so much as when he sees people planning for the future. But I think that you always have to be on guard for a risk of some constitutional attack. But as I say, the history of this country has been pretty good on that score so far as the judges are concerned. And because despite the press and various other organisations saying otherwise, the judicial power is quite limited in this country compared with most countries, so it shouldn't be too much under attack. And the standard of judges, I would say, wouldn't I, but the standard particularly of the senior judiciary is, I think, very high, which helps. I think, therefore, the threat is the one you've identified. And I mean, again, to be fair to the government.
Do you mean funding?
Yeah, funding. But to be fair to the government, so far as the judges are concerned, they've been reasonable about pay and so on. I know that for a very successful commercial silk, judicial pay is very low. But compared with judges across the world, other than in Hong Kong and Singapore, judges are pretty well paid here. And I think in that sense...
So the judiciary is in good heart?
I think the judiciary is in good heart, but the trouble with that is that at times, I think the reason the judiciary is in good heart is, and reasonably well paid, is partly because the Treasury is very anxious to keep the commercial court's reputation high. And the judiciary is absolutely clear you can't pay commercial court judges differently from other judges. And secondly, I think there may be some calculation that if we pay the judges properly, they won't make quite so much fuss about the underfunding of the court system, because they're all right. And I'm sure that very few judges feel like that, but psychologically, you can see the argument.
That's the reasoning. There
is a curious tension in this country because the government's very keen to maintain our standing and reputation as probably the global international law centre of the world. But what lawyers at the normal sort of criminal end, the personal injury, small personal injury claims, the employment, matrimonial, they make peanuts. If you work out how hard they work and how devoted they are, they probably don't even get the minimum wage if you work out their hourly rate.
That is a threat, ultimately, isn't it, to the public confidence in the administration?
It's a very serious threat to the rule of law. And that's been a threat throughout my career. It's a threat the judges have warned against. And it's a threat that, I'm afraid, rather than being mitigated, has got worse.
This podcast was brought to you by the University of Law. Subscribe now to make sure you don't miss the next episode.